Welcome once again to Lehto's Law. Here's Steve Lehto.
I got a note from the Institute for Justice, and here's a case they did not win, but they will continue pursuing it. But it's one of those things you look at and go, wait, what? Appeals court upholds lower court ruling, dismissing lawsuit, challenging New York's scheme of issuing unreviewable code enforcement fees. Unreviewable code enforcement fees. So there's a code that they claim you broke, like a zoning code, municipal code, building code, a code. It's, you've heard of those. And they say, hey, we're accusing you of violating the code. Here, pay this fine or a fee. And you go, I think that's wrong. How do I challenge this? Oh, it's unreviewable. It's unreviewable. So the Second U.S. Circuit Court of Appeals upheld the lower court's ruling, dismissing the lawsuit challenging the New York City Department of Buildings' scheme of issuing unreviewable code enforcement fees. Now, there's a guy here they represent, first sued the city in 2020 after he racked up $11,000 in fines for building a pigeon coop on his rooftop. Now, some people would say, Steve, I don't want a pigeon coop on some guy's rooftop. Well, if there's a code or ordinance or law against it, then, of course, they can do that. But the point is that if they fine him or say, here's a fee that you owe because you did that, and if you stop, we won't do this to you, there should be a mechanism to have a hearing on that, right? So the DOB, Department of Buildings, continues to issue unjustly high fines against New Yorkers for harmless violations, many of which homeowners cannot appeal or even challenge. And that's the point. They're not saying that they should be allowed to build these things like pigeon coops without any ramifications. It's that they should be allowed to appeal it or challenge it on some level. And remember, if you appeal it and challenge it, you can still lose. But the point is at least you got a hearing. So that's the IJ senior attorney speaking. The man received a half a dozen citations from the DOB over a 7-month period for building a pigeon coop on top of his home. Some of the violations came with hearings where he could ostensibly challenge the citations, but some did not. The citations that did not provide an opportunity to be heard did not say that. They simply said, pay this fine. We found that you owe this money. So in the recent decision, the court ruled that the man's case should have been filed sooner because he should have known that some of the violations were not reviewable when the city issued them. So they're saying, look, you had no right to review it, which means you should have sued them for that, and you didn't sue them soon enough. So the court said his filing of the lawsuit in November of 2020 fell outside of the statute of limitations. He's fined because the clock started ticking for the statute at a January 2017 hearing that did not address these violations. According to the court, the man should have known then that he would not get a hearing for some violations. This is despite the U.S. Supreme Court holding just last year that the statute of limitations clock does not start until the government has provided all the process it is going to provide. In this man's case, the process stopped, and the statute of limitations should have started ticking with the last hearing in November of 2017. If they'd used that date, the lawsuit was filed on time. So the man was originally fined $3,000 for moving the coop because he was not aware he would need a permit to do that. Instead of giving up, he hired an architect and an attorney, and he vowed to work with the city to bring the coop into compliance. However, the city continued to demand that he meet unreasonable standards and continued to fine him as he attempted to work with them. By the time he finally gave up and removed the coop, the city had hit him with over $11,000 in fines. The fines that were heard in front of an administrative judge could be appealed, but only if he paid them all first and risked their increasing further on appeal. And again, not every single thing they did to him was appealable. So he said, even though my suit was unsuccessful, for the sake of all New Yorkers, I hope that the New York City Department of Buildings starts treating people fairly. They'll continue to find themselves getting sued if they do not, and one day one of these suits will succeed. Now, New York City has created an impossible-to-navigate legal labyrinth that does not afford people a due process they're entitled to under the Constitution, says another IJ attorney, Diana Simpson. It's unfair to expect New Yorkers to know they will not be permitted the chance to appeal certain fines. Today's decision, unfortunately, gives the city the ability to continue to issue opaque notices that force regular New Yorkers to not only read what the notices say, but decode all the implications of what they do not say. Meanwhile, IJ has another active case against the DOB for fining a resident for a violation he did not commit, but gave him no way to appeal. Additionally, every year, DOB issues thousands of tickets and fines for violations of the city's codes and regulations, which are long, complex, and contained in 3 different sources. Some of these violations are issued for serious problems. No one denies the city should protect public safety by enforcing building codes against, skyscrapers and other major developments. But a growing number of tickets target ordinary homeowners who made inconsequential changes to their own property. For many of these tickets, the property owners cannot mount a defense, and there's no appellate process. For other tickets, the property owners can defend themselves, but they cannot appeal a decision without first paying all the fines up front that the city's levied. So we're obviously disappointed in the results of Joe's case, but we're hopeful that through our other lawsuit against DOB, we can get a win that will protect the due process rights of all New Yorkers, says the IJ President and Chief Counsel, Scott Bullock, who's a nice guy. I've met him, hung out with him, talked to him. He, of course, runs the organization, the Institute for Justice, and they do great work. But here they lost this one. I'm hoping they'll appeal it. But he says they've got another case on point that they're working with, so maybe they'll just take that one. We'll see what happens. But understand that it's most basic, the concept of due process. You've heard about it before. It's featured in some major works of legal art. Some legislation passed a long time ago that you've got the right to due process. Many people don't know what due process means, though, in an actual tangible form. What does it mean to have due process? And some people say, well, at the very basic, the most base, the simplest explanation is that you need to know the charges against you and have a meaningful opportunity to participate and defend yourself against those charges. And so if they don't tell you about the charges, you're out of luck. And if they do tell you about them, but you can't do anything about them, you're out of luck. That doesn't sound like these people are getting due process. So I'm a firm believer that it doesn't matter if the ticket's issued by the dog catcher or by the head of the FBI. There needs to be the ability to defend it and appeal it from the people who gave it to you. So to simply say like, oh, the Department of Buildings gave you this ticket, go to them, they're going to rubber stamp it and go, and you can't appeal that. That's a lack of due process. It sounds like it to me. And one of these things is some people do look at these cases and go, but Steve, seriously, would you fight a parking ticket? Yes, I have. I've mentioned before that I personally fought a parking ticket I got that was unfair, and I fought it on principle. And now I've had people who wanted to hire me to have me fight things for them on principle. And unfortunately, it doesn't always work out because my time can be valuable and I might have, other cases to attend to. But I got a parking ticket that I was so riled up about because what had happened was I went to see a show near and I parked near the theater in my vehicle. And when I got to the show, there was a parking meter that showed that you could put money into it and it had time on it. So I put money into the parking meter so that I had enough time to go see my show. And it did say parking meters are only until a certain time, so I made sure that I at least got to that point in time. And I came out, and somebody had put a bag over the parking meter and put a ticket on my car. And I looked at the ticket, and it said something to the effect of, parking after 6 p.m. or something like that, which was allowed by the sign. So I photographed the ticket, I photographed the sign, I photographed the bag, and I filed an appeal on it. And I went into a district court, and the judge calls the case, and a parking enforcement officer stood there and actually argued about why that was a just fine. And the judge looks at this and goes, wait, the signage says he's allowed to park there, and then somebody puts a bag over the meter, and then he gets ticketed for parking? And the judge was baffled by it too. And see, here's the problem. If you have the power to write tickets and code violations and municipal violations, and you can do this, and if you know that people don't fight them or can't fight them, you start getting a little sloppy with how you write those tickets because who cares? They can't fight them. And that's one of the biggest problems here is that the Department of Buildings in New York City knows that some of these things that they hand out as violations cannot be reviewed. So why bother sticking to any standards on those? Just start handing them out to raise revenue. which is what happens invariably in these cases. So you've got to allow people to have at least some form of review, because if you give too much power to one department and they know that nothing's ever going to check that power, guess what? Boom. Next thing you know, they're putting bags over parking meters and charging you to park there. And it's kind of funny because when I stood up, I was dressed up nice. I dress up nice when I go to court, whether I'm an attorney or a litigant or a defendant. I'm not sure. I guess I was a defendant in the parking ticket case, right? And I walk up the podium, and because I knew that I looked out of place because the day was filled with all kinds of other minor violations. And so I said to the judge, I said, well, Your Honor, just for the record, I want to note that I am an attorney. And she said, oh, thank you. And then she starts talking to the parking enforcement officer about, okay, explain these bags over the meters again. And in case you're curious, what was apparently happening was there was another nightclub near where I was seeing the show. And they had some kind of deal with the city that allowed them to reserve the parking meters in front of their business between certain times. And so if you parked in those, and the weird part is that the side deal sounded illegal to me, but the parking enforcement officer tried to explain it and said, well, we have a deal with this one club that they get to park valet stuff there. And the judge is like, yeah, but do they put up any signs before that saying like you can't park here tonight because there's a show? No, we go out and we bag the meters. Okay, so when Mr. Lehto shows up and there's nothing to indicate that that meter's any different than any other, and he puts a bunch of change into it and walks away, you're saying that you think you can ticket him because you walk up and, in essence, retroactively place a bag over the meter and then say he's illegally parked. And the parking enforcement officer actually said, well, we've been doing this for a long time, Your Honor. That's another problem. How many people do you think paid those fines? So there has to be an appellate process. I'm talking about when it comes to your legal rights. And anytime anybody accuses you of, who put that there? Anytime, I did it again. Anytime anybody accuses you of breaking the law and there are ramifications, i.e. fines, jail time, or your permanent record, whatever it might be, you should have the right to appear before somebody other than who issued the ticket and fight it. So there you go. Appeals court upholds lower court ruling dismissing lawsuit challenging New York's scheme of issuing unreviewable code enforcement fees. That is, of course, from the Institute for Justice. I always tell you, they're great people, great organization. They fight these cases because obviously, if this case goes to the U.S. Supreme Court, the guy trying to build his chicken coop might not have the hundreds of thousands of dollars necessary to get it there. The Institute for Justice will take that case and do what they got to do with it. So they rely entirely on the generosity of their supporters, and many people in my audience do support them. Thank you very much for doing that. But if you haven't done this yet, I'm going to put a link to their webpage in the description below my video. Check that out. If nothing else, visit it periodically and see what kind of cases they're handling. But if you can, support them. They're a great organization. Questions or comments, put them below. Let's talk to you later. Bye-bye.
Thank you for watching Lehto's Law. Never take action until you have clearly answered the question, what happens if I do nothing?